Hey guys, in this video, we're going to talk about the removal of conditions process, how it works, the types of evidence that you should include, and the wait-in time. I'm Latoya McBean Pompey, an immigration lawyer in New York, working nationwide with clients all across the United States and the globe. Contact us at McBean Law to discuss the removal of conditions process, as well as any other type of immigration problems that you might be facing at this time. Let's talk about the removal of conditions process. It can be very intimidating if you were told that you'll need to do the green card process a second time with your spouse. The removal of conditions process is geared towards sifting fraud, looking for fraud. Immigration or USCIS is wearing these lenses called fraud lens or fraud glasses, so to speak. They're looking at every marriage case and considering whether the couple has committed fraud or not. The removal of conditions process applies to couples who had already gone through the I-130 petition process and the beneficiary spouse successfully received the 2-year green card. The spouse only got a 2-year green card because at the time that USCIS approved the case, their marriage was younger than 2 years. So now they have this 2-year green card, and there's an obligation now that before the 2-year green card expires, the couple must do the whole process again, but this time by filing the I-751 petition, not the I-90, which is to replace or renew your green card. Do not make the mistake of filing the I-90 to extend your status in the United States if you're only a conditional resident. That is a big mistake. The form that you're going to need to submit is the I-751 petition to remove conditions. That's the application. So be careful with this and don't make that mistake. This I-751 petition, guys, is typically filed jointly when you're together with your spouse, but there is a way for some individuals to do this on his or her own without the spouse, and I'll tell you about that process in part 2 of this series. Now, you and your spouse will work together on this I-751 application and include evidence to prove to USCIS that you are in a bona fide marriage. USCIS will be looking for evidence that you had compiled over the last 2 years of your marriage or the 2-year period that you have the green card. So be sure to include fresh bona fides. They're looking for evidence of you living together, your marital home. So for instance, if you have a lease, a mortgage statement, mail that comes to the home, or any other evidence that the two of you are living together at this address included in your filing. USCIS will also be looking for additional evidence that you have brought your resources together. So jointly filed tax returns or tax transcripts, bank statements from joint bank accounts. They will also be looking for utility bills such as gas bill, light bill, telephone bills, also insurances. Do you guys have health insurance together or car insurance together? Evidence like these will show USCIS that you're in a serious relationship. You're in a serious, real, genuine marriage. So be sure to include all of these pieces of evidence. Also, if you have any letters that you'd like to include from family and friends who have been part of your life over the last 2 years, include those letters of support or affidavits from these individuals, but certainly include letters from people who know you and have spent time with you so that it is a lot more credible to USCIS that these are people who have spent real time with you. Now, after the case is filed, the beneficiary spouse will receive an automatic 48-month extension. Yes, 48 months, which is 4 years in this status. And then after that, you will receive a notice for biometrics. The government will ask you to come back in and do more fingerprints. For some people, they will tell them they're going to reuse the prints that they have on file, but they're moving away from that, friends, because the government now, under the Trump administration, they do not want stale fingerprints on the record for you. So be prepared to go in and just go through the biometric process after you file the case. Also, friends, some people will receive a request for additional evidence. If you receive such a request, be sure to sit down with a lawyer and go through what the government is asking from you and do it properly. Some couples are interviewed during this process. So after receiving the extension letter, some months will go by and then USCIS will send you an interview notice. USCIS expects both of you to appear at this interview. It's super important that you nail it during the interview because that's where it happens. That's where everything will matter. Everything will come together at that interview. So prepare yourself adequately for this interview. And if you need to hire an attorney to prepare you and to go with you, you should do so. However, USCIS is still waiving some of these interviews. Not very many, but some people are getting the interview waiver still, even under this Trump administration. USCIS has been approving cases before the 48 months. We've seen some clients receive their 10-year green card in 8 months after filing the I-751 petition. For others, it's a year. And then for others, it is longer than a year. So it just really depends on a number of factors with your case. We'll discuss in part 2 of this series the consequences for not getting it right, the consequences for having your case denied by USCIS. So stay tuned for part 2 of this series. And then lastly, friends, you will be able to apply for naturalization even while your I-751 petition is pending. And this happens at the 3-year mark of being a resident. Technically speaking, you could apply for naturalization early at the 2 years and 9-month mark of being a resident. So speak with a lawyer about the advantages of filing naturalization early during this I-751 removal of conditions process. Filing naturalization early isn't for everyone. Do not file for naturalization early if you're no longer together in marital unity with your spouse, because it could lead to a lot of problems down the road. But for most everyone else who is still in a good, strong, supportive marriage, you could submit the N-400 early at the 3-year mark of being a resident. Do not confuse this with 3 years of marriage. No, it's 3 years of being a resident. After submitting the N-400, what USCIS typically does, in some cases, it actually speeds things up with the processing of the removal of conditions, and they will have you come in for an interview and tackle both applications at the same time. And if you do well, you'll be able to be approved for both the removal of conditions and naturalization, and then be sworn in to become a U.S. citizen, bypassing the 10-year green card. Guys, this is a complex process. It's not for everyone. Be sure to get some legal help because things have changed dramatically with immigration. The process still works, the system still works, but you've got to know what you're doing in order to be successful. Reach out to us at McBean Law. We've had a lot of success stories with clients going through the removal of conditions process. You can reach out to us by calling our office at 914-898-9488, or you could go to McBeanLaw.com, fill out our form, and someone from our team will contact you immediately to schedule a consultation. Friends, thanks so much for watching this video. Be sure to subscribe to my channel before you go today and hit that notification bell so that you'll be the first to get notice of my videos each week. I'll see you in the next one. Bye-bye.